Again, to jump back in and finish reading the article, Psychiatry and the Presumption of Expertise, Flipping Coins in the Courtroom, by Bruce Innes and Thomas Litwack from 1974, and we will start back with Part 3, Legal Consequences and Recommendations. From the preceding studies, it is possible to draw the following conclusions. Psychiatric diagnoses are quite unreliable. Psychiatrists are more likely to disagree than to agree about specific diagnoses, such as psychotic depression, paranoid schizophrenia, or passive-aggressive personality. And while diagnoses limited to the broad categories of functional disorder are more reliable, in actual practice, psychiatrists are almost as likely to disagree about such diagnoses as they are to agree. Although the validity of psychiatric diagnoses has not yet been carefully studied, the relevant evidence suggests that it is quite limited. At the least, it is clear that psychiatric diagnoses, especially the diagnostic categories of psychosis and schizophrenia, often suggest the presence of symptoms and/or degrees of psychopathology that simply do not exist. It is equally clear that psychiatrists have absolutely no expertise in predicting dangerous behavior. Indeed, they may be less accurate predictors than laymen, and that they usually err by overpredicting violence. Finally, whether a prospective patient will be labeled psychotic or non-psychotic, schizophrenic or non-schizophrenic, dangerous or non-dangerous, able or unable to care for himself or herself, may be determined by one or more of the following factors: the theoretical orientation and methodology of the examining psychiatrist, the socioeconomic and cultural background of the patient and psychiatrist, and the time, place, and circumstances of the psychiatric examination. In summary, there is good reason to believe that psychiatric judgments are not particularly reliable or valid, and that psychiatric diagnoses and predictions convey more erroneous than accurate information. The legal implications of this demonstrated psychiatric fallibility are obviously far-reaching. Section A. Psychiatrists should not be permitted to testify as experts in civil commitment proceedings. Subsection 1. Psychiatric judgments are not sufficiently reliable or valid to justify their admissibility under traditional rules of evidence. An exception to the ordinary rules of evidence has been created to permit experts to testify in court as to their opinions, conclusions, and judgments. With the exception of psychiatrists, witnesses are required to prove their expertise before courts will permit them to testify as experts. If that same proof were required of psychiatrists, they could not qualify as expert witnesses. Support for this proposition may be provided by analogy to the judicial treatment of polygraph results. There is no question that psychiatric judgments are far less reliable and valid than polygraph judgments. Although the evidence is still accumulating, a conservative estimate is that an experienced polygraph examiner can correctly detect truth or deception about 80 to 90% of the time. Significantly, one study has indicated that an examiner is more inclined to report a guilty subject innocent than he is to report an innocent subject guilty. The converse is true of psychiatrists. If doubt exists, it is almost always resolved to the patient's disadvantage. Predictions of dangerousness afford the prime example. Each of these objections provides a cogent reason also to exclude psychiatric judgments. A. Extraneous qualities of psychiatric patients, such as their socioeconomic class, may substantially influence psychiatric judgments. B. Judges and juries usually defer to psychiatric judgments. C. Psychiatric interview procedures are unstandardized. D. It is difficult for judges and juries to evaluate the validity of individual psychiatric judgments. And E. Psychiatrists and behavioral scientists who have studied the reliability and validity of psychiatric judgments almost unanimously agree that such judgments are of low reliability and validity. Whatever may be said for the reliability and validity of psychiatric judgments in general, there is literally no evidence that psychiatrists reliably and accurately can predict dangerous behavior. To the contrary, such predictions are wrong more often than they are right. It is inconceivable that a judgment could be considered an expert judgment when it is less accurate than the flip of a coin. Accordingly, psychiatrists should not be permitted to testify as expert witnesses until they can prove through empirical studies that their judgments are reliable and valid. Subsection 2. Psychiatric judgments do not convey meaningful or otherwise unavailable information about the issues relevant in a civil commitment proceeding. It is our contention that psychiatric diagnoses often convey more inaccurate than accurate information about an individual, and that a diagnosis suggests that the individual manifests the range of symptoms associated with that diagnosis when, in fact, the individual may exhibit only one or even none of those symptoms. On the one hand, the label psychosis, for example, tells us that the patient presumably exhibits one of 5 symptoms, which could just as easily be described directly without using the diagnostic label. On the other hand, it tells us nothing about the individual's potential dangerousness, the expected duration of his or her condition, whether it can be treated, and, if so, how. Moreover, it does not purport to tell us whether the individual is friendly or unfriendly, cooperative or uncooperative, happy or depressed. In short, the diagnosis itself answers none of the questions that conceivably could be important to a judge or jury in a civil commitment proceeding. Indeed, though a diagnosis of psychosis, by definition, indicates that an individual's mental functioning is sufficiently impaired to interfere grossly with his or her capacity to meet the ordinary demands of life, that definition is essentially meaningless because all of us psychiatrists know basically psychotic individuals who continue to meet the ordinary demands of life and non-psychotic individuals who fail utterly to measure up to this criterion. By way of partial illustration, one study found that only 18.5% of the people living in mid-Manhattan could be considered mentally healthy, free of significant symptoms of mental pathology, while almost 25% of the population was impaired and exhibited mental morbidity. Individuals in the latter group were all characterized by symptom formations that had halting, laming, or crippling effects on the performance of one's daily life. Most of those individuals probably could be considered mentally ill, within the meaning of prevalent civil commitment provisions. Nevertheless, they were living and functioning in the community. Another study, conducted by the National Institute of Mental Health, concluded that as many as 8 million people a year may suffer depression severe enough to merit being treated by a doctor, but only 250,000 Americans were hospitalized for the ailment last year. In other words, only 3% of all persons thought to be severely depressed required hospitalization for that condition. The rest, though depressed, were able to get along in the community. Accordingly, since many psychotic or severely depressed persons do not require hospitalization, those labels do not assist the trier of fact in a civil commitment proceeding in deciding whether or not to commit the prospective patient. For years, homosexuality was listed in DSM-III as a subcategory of personality disorders. Recently, however, the American Psychiatric Association decided by vote that homosexuality should no longer be considered a mental illness. If all that is needed to remove large numbers of individuals from the ranks of the mentally ill and grant them the status enjoyed by the rest of society is a vote by the American Psychiatric Association, then surely other diagnostic labels are also highly suspect. Again, the DSM-III that supposedly revolutionized psychiatry and solved all the problems of reliability was also developed by no better a process through the APA. It should be obvious then that psychiatric diagnoses do not convey much meaningful information. In fact, since diagnoses such as psychosis or schizophrenia have scare word qualities, they often misleadingly suggest to a judge or jury that the individual should be committed to a hospital. Even more serious is the label dangerous, which almost certainly prejudices judges and juries without conveying any meaningful information, such as whether the individual is likely to cause physical injury or injury to property, or whether the only danger is that he eats too little or embarrasses himself at his job. Recognizing that a finding of dangerousness requires a social and legal judgment that cannot be made by psychiatrists, the Supreme Court has acknowledged in a related context that the jury serves the critical function of introducing into the process a lay judgment, reflecting values generally held in the community concerning the kinds of potential harm that justify the state in confining a person for compulsory treatment. Therefore, since psychiatric judgments, diagnostic labels, and terminology convey little meaningful information and may convey more inaccurate than accurate information, judges and juries have no need for them in deciding the relevant issues in a civil commitment proceeding. Since psychiatrists supposedly are trained to observe and describe behavior in concrete terms, there is no need for them to offer opinions. Subsection 3. The admission of psychiatric judgments in a civil commitment proceeding denies prospective patients due process. This point, although essential, can be simply stated. Justifying the deprivation of an individual's liberty on the basis of judgments and opinions that have not been shown to be reliable and valid should be considered a violation of both substantive and procedural due process. Certainly a procedure by which judges flipped coins to determine who would be committed would offend our sense of fundamental fairness. It is our contention that psychiatric judgments have not been shown to be substantially more reliable and valid. Section B. If psychiatrists are permitted to testify as experts, the prospective patient should be afforded a meaningful opportunity to cross-examine and call expert witnesses on his behalf. Subsection 1. Cross-examination. Since many variables other than the actual condition of an individual may influence psychiatric perceptions, descriptions, and judgments, their validity cannot be assumed. Rather, they must be examined to determine whether the data before the psychiatrist supports his or her conclusion. We have seen that psychiatric terminology often conveys misleading information, which is usually prejudicial to the prospective patient. By way of illustration, if a recommendation that an individual be hospitalized rests upon the psychiatrist's judgment that the individual is psychotic, cross-examination might reveal that the diagnosis of psychosis in turn rests upon the presence of only one symptom, voicing delusions, for example. Since the prospective patient did not exhibit any other symptoms of psychosis or any violent behavior or threats, commitment could be justified, if at all, only by the presence of that one symptom, delusions. Moreover, if further cross-examination indicated that the patient's beliefs were not demonstrably true, but not particularly unreasonable or uncommon, exposing the psychiatrist's personal concept of delusion would make the limitations of his or her diagnosis apparent. At present, most cross-examination of psychiatrists is perfunctory or non-existent. One reason that many attorneys accept psychiatric judgments at face value, possibly because they feel incapable of challenging such judgments. Another is that the prospective patient's lawyer, who usually is not present during the psychiatric examination on which the psychiatrist's judgment is based, has little information about the individual circumstances that might have influenced that judgment. Not inconceivably, the psychiatrist might report only those portions of the prospective patient's comments and actions which would support an inference that the individual was disturbed, even though 99% of what he or she said and did would be entirely consistent with what we regard as normal behavior. Nor is it uncommon for psychiatrists to admit qualifying remarks, thereby making the prospective patient's statements seem more irrational than they are. Understandably, the patient often does not remember what the psychiatrist has omitted or misstated, or is in no position to challenge the psychiatrist's recollection of the interview. Consequently, meaningful cross-examination may not be possible unless the prospective patient's lawyer was present when his or her client was examined, and therefore knows what actually happened during the psychiatric examination. Subsection 2. Expert witnesses for the prospective patient. Cross-examination may suggest the fallibility of the opposing psychiatrist and the shortcomings of the psychiatric profession, but calling to the stand the psychiatrist who disagrees with the opposing psychiatrist is an even better way of forcing judges and jurors to use their common sense. In fact, it may be the only feasible method because the so-called independent psychiatrist, despite claims to the contrary, does not exist. The rationale underlying this proposal is that the independent psychiatrist often testifies against the wishes of the prospective patient, with devastating impact on the minds of judges and jurors. Section C. Non-judicial commitment should be abolished or severely circumscribed. Our concern so far has been with the role of psychiatrists in judicial proceedings. In many states, however, persons can be hospitalized involuntarily for months or even years without ever having appeared before a judge or jury. Typically, a certification by 2 psychiatrists or even 2 physicians that a person is mentally ill or dangerous or both will suffice to authorize involuntary hospitalization. There is no evidence that psychiatric judgments made outside the judicial process are any more reliable or accurate than those made in a judicial context. Consequently, the former are just as vulnerable as the latter to the criticisms we have raised in this article. Accordingly, involuntary hospitalization based on medical certification without benefit of a judicial determination of the necessity for hospitalization should no longer be permitted. If medical certification is not abolished, it should be permitted only in emergency situations, where the prospective patient is considered imminently dangerous to self or others. And medical certification should authorize involuntary hospitalization only for the limited time necessary to institute judicial proceedings. Alternatively, if 2 psychiatrists, for example, can sign a person into a mental hospital, 2 other psychiatrists, perhaps retained by the patient or his friends, should be able to sign the patient out. The law should not presume that psychiatric judgments recommending hospitalization are more valid than psychiatric judgments recommending release. Section D. Mental illness and/or need for care and treatment should not be sufficient grounds for commitment. There is no reason to believe that psychiatrists can determine who is mentally ill or predict who requires involuntary care and treatment any more reliably and accurately than they can make other diagnoses and predictions. Given the breadth and ambiguity of these terms and the lack of any agreed definitions for them, such judgments are likely to be significantly less reliable and accurate than psychiatric judgments usually are. At the least, therefore, no person should be involuntarily hospitalized on the basis of a judgment that the person is mentally ill or in need of care and treatment, when the only support for that judgment is the opinion of a psychiatrist. Furthermore, we have found no evidence that the judgment of who is mentally ill or who requires care and treatment can be reliably and accurately made by anyone. In the present state of knowledge, commitment on these grounds is of necessity a completely arbitrary act. No person could be confined under the criminal law solely because of a judgment that the person is a criminal type, because that standard is too imprecise to permit any test of the validity of the judgment. Similarly, no person should be confined under the civil law solely because of a judgment that the person is mentally ill or in need of care and treatment, because these standards are too imprecise to permit any test of the validity of such judgments. Again, the argument that mental illness is nothing short of an inadequate metaphor appears correct. While psychiatry and the mental health industry push mental illnesses, as defined by the likes of the DSM, as medical diseases, there are also no known biological markers for these supposed diseases. Section E. The criteria for commitment on the basis of dangerousness should be severely circumscribed. Civil commitment of persons who have committed no crime, but who nevertheless are thought to be dangerous, is a form of preventive detention that is difficult to justify. We will not repeat here the constitutional and policy objections to such commitments. However, if civil commitment of allegedly dangerous persons is to be permitted at all, it should be severely circumscribed, for there is no evidence that, in those cases in which dangerousness is brought into question, psychiatrists can predict dangerousness more accurately than laymen. To the contrary, the evidence suggests that psychiatrists are rather inaccurate predictors, more often wrong than right in close cases. Accordingly, no person should be committed when the only evidence that he or she is or will be dangerous is the opinion of a psychiatrist. Finally, the meaning of dangerousness should be spelled out more precisely because at present, ambiguity of the term encourages over-prediction. The appropriate standard should require proof that in the absence of hospitalization, there is a substantial likelihood that the prospective patient would inflict major physical injury upon self or others in the near future. Section F. Commitment should require proof of mental illness and dangerousness beyond a reasonable doubt. Proof of guilt beyond a reasonable doubt is a constitutional requirement in criminal proceedings. Both the prospective patient and the accused criminal are subjected to a coercive process buttressed by the power of the state, which may result in loss of liberty. The prospective patient, however, is afforded fewer procedural protections than we give those accused of crime. A substantial argument can be made that every procedural protection guaranteed to criminal defendants should be guaranteed to prospective patients. It is not necessary to go that far. However, in order to suggest that at least some of the procedural protections granted to criminal defendants would preserve important values and foster important objectives in the civil context as well, and should therefore be granted to prospective patients. One of those protections is the requirement of proof beyond a reasonable doubt. Conclusion. In 1964, Judge, now Chief Justice, Warren E. Burger wrote that psychology is, at best, an infant among the family of science, that psychiatry and psychology cannot claim to be truly scientific, and that psychiatrists and psychologists may be claiming too much in relation to what they really understand about the human personality and human behavior. The professional literature confirms Justice Burger's intuitive judgment. Psychiatrists have bitten off more than they can chew. The fault, however, is not theirs alone, for legislators and courts, in an attempt to shift responsibility for making the determination of who shall remain free and who shall be confined, have turned to psychiatry, seeking easy answers where there are none. Human behavior is difficult to understand, and, at present, impossible to predict. Subject to constitutional limitations, the decision to deprive another human of liberty is not a psychiatric judgment, but a social judgment. We shall have to decide how much we value individual freedom, how much we care about privacy and self-determination, how much deviance we can tolerate, or how much suffering. There are no experts to make those decisions for us. This was the state of psychiatry in 1974. And what was the APA doing to address these issues in 1974? It was in the process of trying to reduce the issues of psychiatry down to the reliability problem, while simultaneously developing the supposed solution to that problem, the DSM-III. It had also just begun and was growing its explicitly financial relationship with the pharmaceutical industry. And by 1980, the year of publication for the DSM-III, the APA pretended, like all the major problems of psychiatry, reduced to that reliability problem, had been solved, except that the problem of reliability had not been solved, giving, if nothing else, the appearance of the APA trying to sweep the problems of psychiatry under the rug. It is difficult to say the state of all of psychiatry's issues, present day. However, interestingly enough, even the most recent edition of the DSM-V, has been criticized as being unreliable. I had many further notes about civil commitment, a problem which still continues, but I will leave off here until next time. I hope to see you there.